Good morning. Good morning and welcome to the University of Montana. My name is Elaine Gagliardi, and it is my privilege to serve as Dean of the Alexander Blewett III School of Law. The law school is pleased to once again welcome the Montana Supreme Court to Missoula. I want to thank the court for traveling to Missoula and to other Montana cities so that our communities can watch our judiciary at work. This week, the University of Montana held a democracy summit. The courts are an integral part of our democracy and an important part of the checks and balances built into the structure of our federal and Montana constitutions. While the legislature brings to bear the will of the majority in enacting law, our courts focus on the person, the individual. Courts ensure the protection of the individual rights and the rights of persons in the resolution of their legal conflicts. Thank you for being here this morning and for joining us to hear the oral arguments in Montana Trout Unlimited versus the Montana Department of Natural Resources. The Montana Supreme Court asked the law school to provide an introduction of the case. For those of you who are not familiar with our law school, it offers an outstanding legal program and is a top 100 law school. Our school is a vibrant community of legal scholars, and it includes 2 law reviews, the Montana Law Review and the Public Land Resources Law Review, both focused on the issues important to Montanans. It is my privilege this morning to introduce Alex Clark, who will provide the introduction to the case. Alex Clark is a second-year law student. He graduated from the University of Montana with majors in philosophy and history. He was elected to the editorial staff of the Montana Law Review, and his review of this case will be published in that journal. Please join me in welcoming Alex Clark to provide the introduction of the case. Thank you, Alex.
Thank you, Dean Gagliardi. Good morning and welcome, everyone. My name is Alex Clark, and I'm a second-year law student at the University of Montana's Alexander Blewett III School of Law. On behalf of the Montana Law Review, I would like to thank the Montana Supreme Court for traveling to Missoula to hold this oral argument and for providing me with the opportunity to introduce this case to you today. We are here to listen to the oral arguments in Montana Trout Unlimited versus the Department of Natural Resources and Conservation, or DNRC for short. Many of us may be familiar with the dispute involving Trout Unlimited and the Department of Environmental Quality. That case involved the DEQ's environmental review of the same proposed mine that we will talk about today. But that was a different legal case. While the case with the DEQ involved potential pollution of water caused by the mine, the issue here concerns the availability of water in the Smith River watershed where the proposed mine would be located. This introduction is offered to the public, so I'll provide a lot of background information so that we may all better understand the law that governs us. First, I will explain who the parties are, and then outline the rules for water rights and permitting process in Montana. From there, we'll go over the factual and procedural history leading us to today's oral argument. And I will close by summarizing what the parties will likely argue before the court today. We're here for an oral argument before the Montana Supreme Court. Unlike a trial where there is a jury and lawyers who submit evidence, an oral argument is more like a conversation between the lawyers and the justices of the court. The lawyers have already submitted their legal arguments in writing, and now it is the justices' opportunities to ask the lawyers questions about their legal arguments. The Montana Supreme Court is the highest appellate court in the state involving issues of Montana law, including water rights. That means that this court's decision will be the final say in the matter. An appellate court reviews a lower court's decision. In an appeal, like the one here today, the parties are called the Appellants and the Appellees. The appellants are the parties who lost in the lower court, and the appellees are the parties who won in the court below. Here, the appellants are several conservation groups who represent people who recreate and use the Smith River, including Trout Unlimited. I will refer to the appellants as simply Trout Unlimited. Trout Unlimited has brought other cases before the Montana Supreme Court seeking to leave more water in the state's rivers and streams. The Appellees are Tintina, Montana, and a mining company registered in Montana and incorporated in the state of Delaware, and the Department of Natural Resources and Conservation. The DNRC is the state agency responsible for issuing water use permits. I will refer to the Appellees as the mine and the DNRC. Now that you know the parties, I'll give an introduction of water law before getting into the specific facts of this case. Montana Trout Unlimited versus the DNRC provides an opportunity to better understand how the three branches work together under a constitutional form of government. As you well know, the legislative branch enacts laws through statutes. The executive branch, here the DNRC, enforces the law. And when disputes do arise, the judicial branch interprets what the law means. The state constitution provides a structure that holds these branches together, as well as a baseline of rights that we all enjoy. Because all laws must comply with the Constitution, when a court reviews a law passed by the legislature, it will try to read the law in such a way that it complies with the Constitution. Since pioneer times, Western states like Montana have always required that water is used beneficially and that any waste of water is unlawful. It's kind of like two sides of the same coin. Water use is either beneficial or a waste. Montana's 1972 Constitution affirmed that water rights exist only for beneficial uses. Under the Montana Constitution, the state owns all of the water within its boundaries, and water can only be used for a beneficial purpose under a valid water use permit. The legislature enacted the Montana Water Use Act to carry out its constitutional duty to provide for the centralized regulation of water rights in Montana. The Montana Water Use Act defines beneficial use to mean a use of water for the benefit of the permit applicant. Beneficial uses include industrial, irrigation, and mining purposes. On the other hand, waste refers to the unreasonable loss of water or the application of water to anything that is not a beneficial use. New water permits must also not limit the availability of water for people who have held water rights for longer. You will hear these people referred to as senior water rights holders. The legislature has also enacted special protections for places where rivers and streams do not have enough water available for all of the people claiming a water right. These areas are known as closed basins. The Smith River watershed, where the proposed mine would be, is located in a closed basin. In closed basins, new water permits for surface water are not allowed, but permits for groundwater may be available if the applicant can show that they will mitigate any harm. So, for example, by paying another water rights user to use less water. It's important to note that groundwater connects to surface water. Water from rain and snowmelt naturally seeps into the ground, and this groundwater then feeds the state's surface waters, leading to the rivers and streams. The DNRC is the state agency responsible for regulating water rights in Montana. When someone wants a water right, they apply to the DNRC for a water permit and must show that it would be put to a beneficial use. So, for example, if you needed water to irrigate your farm, you would ask the DNRC for a permit to pipe water from a nearby stream to water your crops. But if a senior water rights holder, say another farmer, was worried that your permit would result in less water for their own crops, they could file an objection with the DNRC. If the DNRC still approved the permit, the other farmer could file a petition with the state district court, asking the court to revoke the DNRC's permit. And if the other farmer loses their case in the district court, they could then appeal to the Montana Supreme Court. And that's a very similar process to how we got to this oral argument today, except that this dispute involves an unusual case of water rights. Usually, people want water, but here the mine would need to get rid of the water. So as an example, imagine that you're digging a hole in the sand at the beach. If you dig deep enough, the hole gets flooded with water. Similar principles apply to an underground mine. When a mine digs out a bunch of copper ore out from the ground, the mine would get flooded with water, unless, of course, you divert that water. The mine at issue here plans to deal with this by removing more than half of the groundwater from its mine, clean it, and then pump it back into the ground. This process is called dewatering. The mine then plans to use the rest of the groundwater to process its copper ore. So, to put some perspective on the quantity of water at issue, the total amount of groundwater that the mine plans to remove each year is 807 acre-feet. That is equivalent to about 3.5 feet of water covering the entire University of Montana campus, from Maurice Avenue to the River Trail. About 57% of that water, or just shy of 2 feet covering all of campus, would be removed without a water use permit every year. The mine hopes to use the remaining 350 acre-feet of water in its ore processing and operate for about 13 years. The Water Use Act says that dewatering a mine without further use cannot be considered an unlawful waste. So what does that statute really mean, though? Is dewatering a beneficial use or some other third thing? The crux of the issue today is whether the mine requires a water use permit for the full amount of water it would need to remove from the ground, or only the 350 acre-feet of water it would use in its ore processing. And this brings us to how we got to the Montana Supreme Court. In 2018, the mine applied for a water use permit from the DNRC for only the water that it would use in its ore processing. Trout Unlimited filed objections with the agency to the permit because the DNRC did not consider the full volume of groundwater to be removed. The DNRC, though, has long held that dewatering is neither a beneficial use nor an unlawful waste. Therefore, the DNRC believes that it lacks the authority to regulate dewatering. In 2022, the DNRC issued a water use permit for just under half of the amount of water that the mine would remove from the ground. Trout Unlimited then filed a petition for judicial review of the DNRC's decision in the State District Court in Marr County. In its petition, Trout Unlimited asked the district court to revoke the mine's water use permit, declare that dewatering requires a permit, and then send the case back to the DNRC to consider the entire volume of water that would need to be removed. The district court judge reviewed the DNRC's decision de novo and agreed that dewatering of a mine is not a beneficial use requiring a water use permit. De novo means that the court gave the case a fresh look without relying on any conclusions made earlier. The State District Court reasoned that the exemption of dewatering from being considered a waste was meant to protect water which is removed from the ground from being wasted later on. The District Court further reasoned that dewatering is neither a beneficial use nor a waste, and that if the law is ambiguous, the DNRC's long-standing interpretation is entitled to some deference. Finally, the District Court was unpersuaded by Trout Unlimited's constitutional arguments because of the decision in Clark Fork Coalition versus DNRC. In that case, the Montana Supreme Court held that the primary purpose of the Water Use Act is to protect senior water rights holders, and that Montana's constitutionally required environmental protection laws are enacted by the Water Quality Act and the Metal Mine Reclamation Act, administered by the Department of Environmental Quality, not the DNRC. The district court upheld the DNRC's decision to issue a water use permit to the mine in April 2023. Trout Unlimited then appealed to the Montana Supreme Court seeking to overturn this district court's decision. Today, the court will likely hear 4 central lines of argument. The primary issue is whether dewatering a mine requires a water use permit and where dewatering fits between a beneficial use and an unlawful waste. Trout Unlimited will likely argue that the several water rights provisions in the state constitution should be read holistically to find that the state's water resources must be comprehensively regulated and protected. Trout Unlimited may argue that the DNRC's wholesale exemption of dewatering is not the kind of regulation that the constitutional framers intended, because, as shown here, it allows too much groundwater to be removed for a significant amount of time without a permit. The DNRC and the mine may respond by reiterating the holding in Clark Fork Coalition versus DNRC that the Water Use Act's primary purpose is to protect senior water rights holders, and that Montana's constellation of environmental protection laws is chiefly made up of the Water Quality Act and the Metal Mine Restoration Act. The mine and the DNRC will likely argue that Trout Unlimited's concerns are therefore unfounded because the water will ultimately be returned to the ground. A second issue may be whether the mine gets a beneficial use by removing the groundwater. Trout Unlimited will likely stress that because the mine is of little use if it is flooded with water, dewatering is necessarily a beneficial use. Trout Unlimited may argue that diverting groundwater from a mine requires the same water use permit as diverting surface water to irrigate a farm. The mine and the DNRC will likely argue that the legislature intended to exempt dewatering from permitting, that a beneficial use requires an active use of water for a purpose like irrigating a field, and that the water is no beneficial use at all because it's in the way. The DNRC may also argue that its authority only applies when one seeks to use water, not when water is a hindrance. The mine and the DNRC may urge the court to reject Trout Unlimited's binary view that every interaction with water is either a beneficial use or a waste. A third issue may be whether the mine's plan to rearrange groundwater and then pump it back into the aquifer is a secondary beneficial use. Trout Unlimited may argue that the mine is getting a second benefit by piping the water it doesn't use in its ore processing back into the aquifer because returning water to an aquifer is often considered a beneficial use. In response, the mine will likely highlight that it has purchased existing water rights to offset depletions to surface water caused by the mine's permitted use of 350 acre-feet of water, so it does not need to recharge the aquifer at all. The mine may argue that it is simply getting the water out of the way. The DNRC will likely argue that the mine must pipe the excess water through its treatment facilities before returning it to the ground in order to comply with the Department of Environmental Quality's standards for mines and is therefore not a secondary beneficial use. And finally, a fourth issue involves the level of deference that the court should grant to the DNRC's interpretation that dewatering is exempt from water permitting. Agency deference is an issue that comes up a lot in American courts. The justification is that it would be wise to give those charged with administering a statute, here the DNRC, a level of deference based on their expertise and closeness to the facts on the ground. In Montana, an agency's interpretation is entitled to respectful consideration. In practice, respectful consideration exists on a spectrum between ensuring that the agency's interpretation is correct to more of a focus on the agency decision-making process rather than the decision itself, depending on the unique factual circumstances of the case. Trout Unlimited may argue for a less deferential standard because the issue at hand is a legal one, and the court knows the law best. In contrast, the mine and the DNRC will likely argue that the agency's long-standing and practical interpretation should be given more deference. Whether dewatering a mine is always exempt from water use permitting requirements in Montana is an issue of first impression, meaning that the court has never considered the question square on. The parties will try to show how the court's prior decisions better favor their own position rather than their opponents. The parties will also try to show how prior cases that maybe aren't so good for their position are factually different than the one involved here today. Today, the parties seek to resolve a near decade-long dispute involving a proposed copper mine in the watershed of the Smith River. The court will answer an open question of whether dewatering a mine is a beneficial use requiring a water use permit. In this oral argument, you will first hear from the attorneys for Trout Unlimited, who are granted 40 minutes of argument. Then you will hear from the attorneys representing the mine and the state, who are together allotted 30 minutes of argument. At the end, the justices will take the arguments under advisement. In the coming weeks and months, the justices will deliberate and discuss the issues amongst themselves before issuing the court's final decision. That is the introduction, and I thank the Montana Supreme Court for the opportunity to introduce this case to you all on behalf of the Montana Law Review. Thank you.
All rise and give your attention to the Honorable Justices of the Montana Supreme Court.
Good morning. Want to check the mics here. It sounds like it's working. I want to thank everybody for attending today. Particularly want to thank Dean Gagliardi and the School of Law for helping to organize this event, along with the University of Montana. We come every year. We particularly enjoy coming over here. Some of us, this will be our last argument in Missoula, and I think probably we'll both miss it, but we're very glad to be here today. We want to thank the students for putting together the introduction. Let me take a moment for those of you who don't know all of us to introduce the members of the court. On my left, on the far end, is Justice Jim Rice. We have Justice Jim Shea, Justice Lori McKinnon. On the far right, we have Justice Dirk Standifer, Justice Beth Baker, Justice Ingrid Gustafson, and I'm Mike McGrath, the Chief Justice. With that, we'll begin the argument. Counsel ready to proceed?
Good morning, Your Honors. May it please the court and the good people of Missoula, too. My name is Sean Helly, and I represent the appellant organizations in this case. I would like to reserve 10 minutes of my time for rebuttal. The facts of this case present this court with a question of critical importance to Montana's waters. Tintina wants to dig a copper mine near Montana's Smith River, in a basin that is already suffering, to quote this court, a crisis of overappropriation. In addition to copper ore, Tintina's underground operation will ultimately unearth nearly 3 billion gallons of groundwater, water the company intends to pump, treat, and sometimes store for months at a time above ground. Under Montana's Constitution, every gallon of this groundwater is the property of the state of Montana for the use of its people. And under the Water Use Act, the public's interest in its water is zealously protected. According to the plain language of the statute, Tintina is prohibited from either constructing or operating its diversion and impoundment without first obtaining a water use permit from Montana's Department of Natural Resources and Conservation. And in order to obtain a lawful permit, Tintina has to develop a plan for mitigating the adverse effects of its entire diversion, nearly 250 million gallons of groundwater a year. We're here today because Tintina failed to fulfill these requirements and the department refused to enforce them. According to the Appellees, the protections of the Water Use Act are subject to an unstated exception that allows for unlimited groundwater pumping at mines across the state of Montana. As a result of this loophole, the argument goes, Tintina only needed a permit and a mitigation plan for the fraction of its diversion that the company wants to put to further beneficial use at its Black Butte mine. The rest of the company's diversion, the Appellees have declared, is somehow beyond the reach of the Water Use Act, which has rendered the department entirely powerless to regulate it. Tintina's unlimited dewatering loophole and the DNRC's unlimited dewatering loophole and Tintina's unpermitted diversion are irreconcilable with the language, purpose, and structure of the Water Use Act and Article 9, Section 3 of Montana's Constitution. In order to protect Montana's waters and the rights of senior appropriators across the state, this court should both reject Tintina's unlawful mining permit and reject the unlawful dewatering loophole that the department has announced in this case. Because this is a statutory case, we need to begin our discussion this morning with the language, structure, and purpose of the Water Use Act. As this court has repeatedly acknowledged, the fundamental core purpose of the Water Use Act is the protection of senior water rights, including the rights that protect our farms, towns, and wildlife.
Counsel, excuse me, it seems to me that on the statutory side of this argument, the issue cuts down very narrowly to what the Act defines as a beneficial use. And is it not a pure question of fact applied to the facts of a particular case, what a beneficial use is within the framework of the definition of the statute?
The question, there are a couple of questions about beneficial use. The question in this case is a purely legal one, as even the department has acknowledged. We are talking about...
The legal question is how to interpret the beneficial use definition. What I'm asking you is whether you agree or disagree that the definition is what it is. So the question is, how does that apply to the facts in a case? Is that not correct?
To a degree, Your Honor, I think it is correct. But in this instance...
To a degree, how is it not correct?
The question of beneficial use is a defined term under the statute. And so while there are relevant facts, for instance, as the Water Court acknowledged in one of the cases cited by the amici in this case, there are questions as to the quantity, factual questions, as to the quantity of water that are dedicated to particular beneficial uses. But the meaning of the term beneficial use itself is a legal question.
Right, and that's what I'm trying to get at here, is I don't understand the point that you made. It's in your briefs, of course, and more briefly today in your introduction, that the definition of beneficial use in the statute, which DNRC is trying to apply in this case, is somehow inconsistent with the purpose or tenor of the Act. I don't understand that. Could you explain that, please?
I would be happy to explain it. Again, the fundamental purpose of the Water Use Act, and this court has made this point clear again and again, is the protection of senior water rights, rights that can include in-stream flows that protect wildlife and other public interests. The Act protects senior rights by dividing applications of the state's scarce groundwater resources.
Excuse me, counsel, that's not my question. My question is, I understand what the purpose of the Act is. My question is, how is the definition, the statutory definition of a beneficial use, somehow inconsistent with the purpose or other provisions of the Act?
The statutory definition of beneficial use is not at all inconsistent with the purposes. It furthers the purposes of the Act. The problem we have in this case is that DNRC has offered an interpretation of that statutory definition that is both unlawful, it's irreconcilable with the plain language of the statute, and it defies the fundamental purpose of the Act to protect senior rights holders. And I'd be happy to explain this for the court.
Please.
The definition of beneficial use under the statute is pretty much what you would expect. Beneficial use is a use that benefits someone, be it the appropriator, the public, someone else. There are particular, this is in Section 102 of the Act, it goes on to say that there are particular kinds of uses that Montana has recognized as beneficial. One of them is the use of water for mining purposes. So what the Act does is it divides these beneficial uses, uses that benefit people in some way. Those are allowable under the statute, but only with a permit. Under Section 312 and 302, The only way you can apply water to a beneficial use in the state of Montana is by satisfying the permitting requirements of the Act, which are set forth in Section 311, and convincing DNRC that your appropriation of water, your beneficial use, will not adversely affect senior rights holders. That's the allowable category of water uses in the state of Montana. The second part of this is the prohibition on waste. Under the definition section of the Water Use Act, a waste is the application of water to anything but a beneficial use. So it's everything but a beneficial use, and it's prohibited under the statute. People are not allowed to waste Montana's scarce groundwater and surface water resources. So the question in this case is whether or not dewatering is a beneficial use that can be permitted by the department, but only after Tintina has satisfied the permitting requirements of the Act, which again under Section 311 require a thorough analysis demonstrating that the pumping and impoundment of groundwater, in this instance 807 acre-feet a year, nearly 250,000 gallons of water a year, nearly 3 billion gallons over the life of this mine.
So counsel, let me ask, and I understand this follows your discussion about the definition of beneficial use. I think everyone agrees that mining is a beneficial use. And I was trying to think how to ask this question that didn't sound so simple that it's obvious, but I think it kind of boils down to this. The mine says, yeah, we're going to use about 40% of this water that's going to come into our mine, and we've applied for and qualified for, and we got a permit for that, and we're not going to use 60%. We're just going to put that back. So doesn't it come down to not just beneficial use, but what is use of water?
I think you're right, Your Honor. I think that is the ultimate question in this case. And I want to make a couple points in response to that. First, a factual point. In their briefs, both the state and Tintina repeatedly suggest the unpermitted portion of the company's diversion, up to 457 acre-feet a year, will simply be pumped out of the ground and returned immediately into the ground. This is false. For 3 months a year, in order to comply with a seasonal surface water quality standard for selenium, Tintina will be impounding its unpermitted diversion, which will result in a number of things. It will result in the loss of water to evaporation, and it will also result in significant hydrological impacts because when this groundwater is impounded above the surface, it cannot be accreting to streams. It cannot be, of course, in the ground. And so I think it's important when you look at Tintina's and the state's arguments about this question of use, you need to understand that we're not simply talking about pumping water and returning it to the ground. There is a period of up to 3 months a year when this unpermitted diversion will be under the company's complete control and possession, and that is, under any sensible understanding of the term use, a use. And so the factual part, you've noted that the real ultimate question in this case, what is a use? And if they're pumping water and impounding water in order
Counsel, the use that you're trying to characterize this as is the use that DEQ is requiring under the environmental regulation side of this to make sure that water quality that is in the ground or going back into the ground is adequate. That's the use here if you're going to apply a literal meaning of the term use. So how is that beneficial to the user, in this case, Tintina?
First of all, yes, you're correct. That there is a use of water here. It's pumping and impounding the water for up to 3 months at a time. And you're correct that the impoundment is in order to comply with water quality standards and a requirement that DEQ has imposed. The benefit here is clear. Tintina has suggested, and the state has also indulged this notion that Tintina doesn't want its unpermitted diversion at all. It would be better off if the water wasn't there. And this suggests that somehow Tintina doesn't want to be pumping and impounding water at all. And the problem with this argument is that Tintina does, in fact, intend and desire to pump every gallon of water it will have to pump at the Black Butte mine, because that pumping is essential to its mining operation. And its mining operation will definitely benefit Tintina in significant ways. So the narrative in this case that Tintina is somehow pumping and impounding water that it just doesn't want to pump and impound is fundamentally false. This is essential to Tintina's underground mining operation, it would be essential to any underground mining operation in the state of Montana. And so to characterize this as a non-use of water because Tintina says it doesn't want to do it, I think it's just factually wrong.
That's an aside argument. I don't disagree with what you're saying about that as far as it goes. But the question in my mind is what is if we're going to call this a use and then in turn a beneficial use, what is the beneficial use to which Tintina is going to apply this water?
The beneficial use, Your Honor, is for mining purposes. And that's under Section 102 of the statute. That is one of the stated meanings of beneficial use, the dedication of water to mining purposes. And I think it's worth Tintina's...
Counsel, I've got two related questions.
Yes.
First of all, have we ever held, or is it in the law, that storage of water alone without application to a beneficial use is a water right?
In the definition of appropriation, Your Honor, it's divert, withdraw, or impound water, a quantity of water. And so an impoundment fits within the square legal definition of appropriation. And I would also note, if I could quickly, Tintina has, in its brief, offered up some definitions of the word use, noting that the term use itself is not defined in the statute. In moments like that, this court will revert to dictionary definitions. And Tintina itself ultimately falls into the idea that use is the employment or control of something for a purpose. And I think it's important to focus in this case on the fact that for the entire period that Tintina is pumping and impounding its unpermitted diversion, that water will be under the company's exclusive possession and control.
So that gets to my second question, because you mentioned that while it's going to be returned, it will lose something in the process. And my question is, has there been any analysis of that quantity, what won't be returned to the aquifer or the surface water?
You've pointed to one of the critical issues in this case. There has not been that analysis because under the theory of the state and Tintina, this unpermitted diversion is not something that's subject to the permitting requirements of the Act.
So then can it be assumed that we don't know if there is any threat to senior appropriators? Or is there any evidence in the record of the potential impact on senior appropriators who aren't parties here?
One of the striking facts about this case is Tintina has pretended that it has two diversions, a 350 acre-foot diversion, which it's gotten a permit for, and a 457 acre-foot diversion, which it says it does not need a permit for. Tintina did analyze that 350 acre-feet, and it did put together a mitigation plan that recognizes the full consumptive amount of that 350 acre-feet, which I think amounts to 340.3 acre-feet of water a year. Based on the analysis Tintina did for the permit, the inadequate permit it did get, we know that the full amount of that use will result in depletions in Sheep Creek, and that it will also cause harm to Black Butte Creek and Coon Creek. So we know from the limited analysis Tintina did do that this pumping and impounding has significant hydrological impacts. With respect to Tintina's permit for less than half its diversion, the department required the mining company to acquire water rights to offset those depletions, that potential adverse effect to senior rights holders. With respect to the majority of its diversion, there was no analysis, no mitigation, nothing at all. The state and Tintina just pretended that this was a non-event under the Water Use Act, and so we have a perverse situation, and I think it's worth focusing again on the fact that the Water Use Act, the legislature made it very, very plain that the purpose of this act is to protect senior rights holders. And it intended to protect senior rights holders, this is in section 101(6) of the act, by comprehensively adjudicating existing rights, the rights that were established prior to 1973, and comprehensively regulating water use in the state. In the following sentence of section 101(6), the court noted, or the legislature, noted that it was its intention that the state assert its authority to regulate water to the fullest extent possible. So the Water Use Act was a plain effort on the part of the legislature to empower and require DNRC to fully regulate the use and application of water within the state of Montana to protect senior rights holders.
So in that regard, isn't this, or why isn't this really a premature argument? I mean, senior water rights holders are not parties, and we don't know, they don't know, apparently nobody knows what impact the amount of water that's going to be impounded and returned will be depleted. A lot of it's underground, a lot of it's groundwater in the first place. So why isn't this a premature argument on that regard?
I think under the law that was in existence prior to the Water Use Act, it may have been. Before the Water Use Act was adopted, senior rights holders were expected to fend for themselves and prove when other people had diverted water, impounded water in a way that caused them harm.
I'm not arguing standing. I'm just arguing, why isn't it premature?
Under the Water Use Act, and I think this court's decision in Montana Power Company versus Carey is really instructive on this point, there was a fundamental sea change in that the legislature established a prophylactic permitting system that lifts the burden of demonstrating adverse effect from senior rights holders and requires applicants for new diversions of water to demonstrate that what they want to do will not adversely affect a senior rights holder, an existing water right. And so what the Water Use Act fundamentally requires is an upfront, pre-construction, pre-diversion demonstration by someone who wants to make a new use of Montana's waters. They have to demonstrate that there will be no adverse effect to an existing rights holder. That burden belongs to them, not the state, not the existing rights holder. And so the moment for these requirements to be enforced is actually right now. Under Section 311 of the statute, Tintina had to make the demonstration that its 807 acre-foot diversion would not cause harm to senior rights holders. It is not the obligation of senior rights holders to demonstrate after that diversion has already taken place that there would be an adverse effect. And I also, oh, sorry, Your Honor.
Well, so you seem hung up a little bit on that they're impounding it. And so if they weren't impounding it, and it was just going back, just going around the facility or being diverted around it, would your position change?
The definition of appropriation, again, is to divert, impound, or withdraw a quantity of water. You can get a permit to do that for beneficial use. So I don't think the impoundment is essential. I think it's important in this case because it demonstrates significant hydrological impacts that this court should not turn its back on. Again, there will be a large loss of water to evaporation from that impoundment. While the water is impounded, it can't be in the ground, it can't be in area streams. And the impoundment, based on its location, it will not benefit Black Butte Creek and Coon Creek. So this is a case in which, while Tintina is trying to tell the court there's nothing happening here, there's actually a lot happening.
So are you then excluding the underground aquifers and the underground storage?
So as I understand it, the infiltration galleries are connected to the storage, but they ultimately return. That's what's used to return water. The 3-month impoundment is to keep the water out of the infiltration galleries during that period where it could cause problems for surface waters.
Council, the Water Use Act is not a new concept in the West. How have other states addressed, I mean, this is a matter of first impression here. Do you have any guidance in terms of how other states and legislatures have addressed this issue, courts or legislatures?
Yeah, I'm not as encyclopedic on that as I'd like to be, but I can tell you New Mexico has a dewatering program that functions like dewatering should be treated under the Water Use Act, where there is a permitting requirement and a requirement that any impacts from mine dewatering be mitigated, that the rights of senior rights holders be protected. I think Nevada has a similar scheme.
And that's by statute?
Yes.
How about Colorado?
It's a good question.
Okay, all right. I'll ask counsel for Tintina.
Thank you for letting me off the hook.
But getting back to the issue about the impoundment that Justice Gustafson asked, your answer was sort of twofold. One, that we have to look at the facts of this case, that there is this 3-month withdrawal period, but also the statutory definition includes any diversion, impoundment, or whatever. So I think that gets to the argument that the amici have raised, which is that your interpretation would mean any dewatering for any purpose would require a permit. And there's a lot of dewatering that goes on by farmers and ranchers and other cities. How do we thread this needle to not, require permits for the universe of water diversion?
Yeah, I think in thinking about that issue, it's really important to focus on the structure of the Water Use Act that was designed by the legislature to deal with this kind of situation. Again, there's the basic binary between allowable beneficial uses and prohibited wastes. There is also under Section 306 a set of explicit de minimis exceptions to the Water Use Act's permitting requirements that can be applied where the legislature has determined that a proposed use of water, potential use of water, is sufficiently small that it couldn't adversely affect existing rights. This court in Clark Fork Coalition versus Tubbs stepped in to ensure that those stated de minimis exceptions, that was the exempt well provision, are kept to de minimis limits, which were 10 acre feet. In that case, we're talking about an unpermitted 457 acre foot diversion here. So in thinking about what should be exempt from permitting, I think the court should focus first on the fact that Section 306 includes legislative determinations that certain uses of water are sufficiently de minimis that they should not require permitting. The other important point about Section 306 is the penultimate provision, which grants DNRC the authority to establish additional permitting exceptions by rule. Rules adopted pursuant to Section 113 of the Act, which allows any regulation that would be useful in carrying out the provisions and purposes of the Water Use Act. So DNRC, to the extent that there are uses of water, that diversions, impoundments, withdrawals of water, that don't make sense in terms of subjecting them to the permitting requirements, that are de minimis, that wouldn't possibly threaten the senior rights the Water Use Act is aimed at protecting, the Department of Natural Resources and Conservation has clear authority under the Act to adopt rules exempting those particular uses from the Water Use Act. What's striking about this case is that it has not done so here. First of all, I would note that dewatering, if there was a dewatering exception in the Water Use Act, it would be in Section 306. You're not going to find it there. What you will also not find is any formal legislative action by DNRC, a regulation, declaring the so-called dewatering policy in a way that would fit within.
But counsel, let's talk about that a little further, because to follow up on this question from Justice Baker and your answer, this isn't an issue of a statutory exception or even an administrative exception. This isn't a policy issue, an administrative agency policy. This is a pure question of law about how to interpret or what statutory terms mean as defined, as expressly defined by the legislature. And you made the point that, well, there hasn't been any legislative action. Now, I don't agree when agencies come to the court and say we should defer to them on pure questions of law, because we shouldn't and we don't. But their historical interpretation of this statute does have some relevance, however, insofar as they point out in their briefing that the legislature has been aware of this for some time and has done nothing about it. And so why is it incumbent upon this court to somehow alter or constrict or expand a statutory definition to address a problem the legislature is aware of and has not addressed?
I think you're right, Your Honor, in noting that this is ultimately a legal question about the meaning of the statute. And what this court has made clear in case after case, the state and Tintina both do make arguments about legislative acquiescence, suggesting that you're not going to see this exception in the statute, but the legislature knew about it, so we should pretend it's there. And what this court has noted again and again is that it is the job of this court to say what the law is. And in doing that, it's the obligation of this court to carry out legislative intent as manifest in the statutory language. So the state in Tintina would have us look, go ahead, Your Honor.
No, finish.
The state in Tintina would have us look at these other supposed legislative awareness of dewatering and the notion.
I don't buy that either. I don't mean to suggest that either. I think that's kind of a weak statutory interpretation argument.
Agreed.
But I think that the problem here is that we still come back to the legislature has defined these terms in plain English. They're not ambiguous. They're not vague. And if a situation that comes up in regulation falls outside of a definition, then it falls outside of the definition, but that's not for this court to fix. That's a legislative matter, is it not?
That is right. This court, it's Statutory Interpretation 101 and Section 101 of the Canons of Interpretation in Montana. You cannot add to a statute what isn't there. You cannot strike from a statute what is there. And I think in this case, what's really striking, DNRC will tell you again this morning that for 40 years, they have been insisting that dewatering is exempt from the requirements of the Water Use Act. But what they have never done in contested case decisions, in policy memorandums, they have never managed to square that position, that desired policy outcome, with the language of the statute, which requires permits for beneficial uses. And if you look at, Tintina again has offered up dictionary definitions of use that make it clear that if a company is controlling or employing something, water, for a purpose, it is using that water. That is true in this case. And I think what's really striking, if you look, and I've spent more time now reading through these DNRC policy documents than I really would have liked to, but if you look closely at the DNRC's decisions and memoranda over time, you'll see this undercurrent where they ultimately define use as requiring, meaning that the person who will be diverting or impounding water needs the security of a water right, wants a property right in the water that will have to be diverted or impounded. That is where DNRC ultimately lands, saying this is the mark of a water right, this is the limit of our jurisdiction. This is an agency that is telling this court it does not have power to regulate a diversion or impoundment if the person who's going to do it just says, I don't want a water right. At that moment, according to this agency, it is powerless to step in, evaluate the proposed use, and ensure that senior rights are not affected.
But that has some support in the statute, doesn't it? I mean, the statute says appropriate means to divert, impound, or withdraw for a beneficial use, and a person may appropriate water only for a beneficial use. So, I mean, it's sort of, goes around in circles, because if you don't intend to apply, in other words, the department can cease acting on a permit if there's not a bona fide intent, and then the permit expires if during the time period it's in effect, there is no application of water to the proposed beneficial use. So, I mean, the department didn't just make this up out of its own policy to not deal with stored water.
Well, I think if you look, what's interesting about the department's policy is their effort to square the meaning of use with this desire for the security of a water right. And according to Tintina's own definitions, there is no way to fit this desire for the security of a water right into the meaning of use. And what I think is really interesting ultimately about DNRC's position, again, this is a statute that was adopted to protect senior rights. And if you look at the provision, this court has noted, if you go section to section, you see this refrain where we're trying to determine, either under the mitigation requirements of 360, the permitting requirements of section 311, whether or not a proposed application of water will adversely affect existing rights.
But the permitting is for a water right.
The permitting process, it creates a water right.
Right, so if they don't want a water right, how does the permit apply? What permit is DNRC supposed to issue?
The permit would be a water use permit, and I think it's important to recognize that with the Water Use Act, yes, the permitting process results in the grant of a water right, but the design of the process is fundamentally aimed at ensuring that new applications of water do not adversely affect existing rights.
So, counsel, is the tributaries into Sheep Creek are going to be affected?
Yes.
So aren't we, I mean, that's a senior water right.
Yes, and if you look at the preliminary determination, they catalog the existing rights in all three affected streams here. I think I should close to save some time for rebuttal, but I would emphasize for the court that what DNRC's interpretation in this case ultimately does is flip the Water Use Act on its head. According to DNRC, the only people who need to apply, the only people who are subject to the permitting requirements of the Act are those who themselves want a water right but do not yet have one. That interpretation elevates the interests of those who do not have rights over the senior rights holders that the Act is actually intended to protect. And so in asking you to reverse the DNRC dewatering loophole and invalidate Tintina's unlawful permit, we're asking you to uphold the fundamental purposes of the Water Use Act and to protect the state's existing rights holders. Unless the court has more questions, I'll save the rest of my time for rebuttal. Thank you.
Good morning. May it please the court, John Teets for Tintina, Montana. I'm here today with co-counsel Haley Franson. Tintina is going to be splitting time with DNRC. I will be addressing primarily the conservation objector's lack of standing to object to either Tintina's water use permit or DNRC's decision regarding the non-beneficial use of water for mine dewatering. Mr. Bramlett will be addressing the reasons why the court should affirm the DNRC's decision that mine dewatering standing alone is not a beneficial use of water, and that the department's longstanding interpretation of that issue. Tintina therefore asked the court to dismiss this case due to conservation's lack of standing, and the alternative, affirm the district court's order dismissing conservation objector's petition for judicial review. Before I jump into the issue of standing, I did want to address a couple of things that the counsel for conservation objectors stated. First, the only issue that's before this court is beneficial use, and whether or not mine dewatering is beneficial use. And most of their discussion has to do with the effects of that decision, but the fundamental decision is this a beneficial use? And as I think that Justice Standifer was correctly noting, that there is no use here. I mean, to use an analogy, if I take my cell phone out of my pocket and I put it in the other pocket, I can't be saying that I used my cell phone. And that's essentially what we're talking about here, is that it's a relocation of water, and there is no use.
The counsel, I have to point your attention, and you may not know about it, but it's from the Colorado Supreme Court, and they specifically say that the process of coal bed methane extraction, quote, uses water by extracting it from the ground and storing it in tanks to, quote, accomplish, quote, a particular purpose, the release of methane gas. The extraction of water to facilitate production is therefore a beneficial use. I mean, I don't see how you can distinguish that. I mean, it's Colorado, but that analysis from what's taking place here.
I think it is distinguishable, Your Honor. I believe that's Vance v. Wolf.
Yes.
And the issue in that case is that the extraction of coal bed methane coal bed methane to a certain extent is entrained in the water. And so you're essentially mining the water in that case of coal bed methane. And so the water becomes a product that is actually producing the product that you desire.
Well, how is that different from what's taking place here? You're drilling the workings are because to get to that substance, you're drilling, and during that process, the water is being produced, and you have to get rid of that water. You're using that water.
That's correct. And the question is whether we're using the water. And contrary to what counsel has said, Tintina would be far more benefited if the water was never there. And it's not integral to the mining. But
it's there. It's there.
This is true. And they're doing a lot to try to diminish it. I believe the distinction, I believe that Vance also says that mine dewatering alone, the nuisance water in mine dewatering, is not a beneficial use. And it's in dicta in that case. But that case does say that the mere mine dewatering is not a beneficial use. And I think that if you review other case law, other prior appropriation state case law, there's nowhere where it says that the mere dewatering of a mine is considered to be a beneficial use. And in fact, the New Mexico statutes that council just referred to specifically says that mine dewatering is neither a beneficial use nor a waste of water. And
But
so
I think you still have to go through the permitting process.
it's a
in New
different
Mexico?
permitting process. It's not permitting process as a beneficial use. It is a process where it does look at the effects of that. That's correct. But it's not doing it on the basis of saying it's a beneficial use that you have to apply for a beneficial use permit for.
Well, thanks for distinguishing Wolf, but essentially, either the courts are addressing or the legislature is addressing in whatever form of statute a loophole that is existing here as well.
Your Honor, I would disagree that it's a loophole. I believe that the legislature specifically made a decision with respect to mine dewatering. That's why you have mine dewatering mentioned in 505 in conjunction with the drainage of land. And nowhere in prior appropriations doctrine, from my research, will you find a situation where a court found that mine drainage or drainage of land was considered to be a beneficial use under the prior appropriations doctrine. That has always looked at those uses, at those manipulations of water as being just that. It's a manipulation of water, but it's not doing so for a beneficial use. I think to me, the crux of beneficial use is that you're using the corpus of the water to achieve a beneficial purpose. And if you're not using the water, then it's not a beneficial use. And
well, aren't you, when you impound the water and treat it and then recharge it into Sheep Creek, isn't that for a beneficial purpose?
I guess, Your Honor, I don't see how it could be. I mean, it is impounded to meet DEQ discharge requirements. That's correct. But the impoundment is part of a diversion. So it's a diversion or impoundment for a beneficial use. I still don't see that there's any use of water in the impoundment. Yes, it impounds, but there are many situations where water is impounded. There are flood water. The major dams in this state have impoundments for flood water. There's no permit for that. Some of the conservation objectors own stream restoration projects impound water. There's never been considered a beneficial use for that. So the mere impoundment of water is not a use. There still has to be a beneficial use behind that for the impoundment, and this is just to maintain water quality.
Well, but then there's also the treatment and the release of it back into Sheep Creek.
That's correct.
So why are you doing it if it's not benefiting anybody?
Well, we're doing it because we have to meet DEQ standards for the discharge. I mean, if the mine could, it would just discharge and return it back. I don't believe that it is really distinguishable that they happen to store it for a period of time.
So I think I have some follow-up questions that I might save for Mr. Bramlett on that. If you want to address your standing argument.
I would, Your Honor. Thank you. There were three issues that were brought up in conservation objectors' reply brief that I wanted to address with respect to standing. First, they stated that Tintina didn't bring up their standing issue timely. Under MAPPA, you can't bring up a new issue on judicial review unless it's brought in front of at the administrative proceeding, and that's simply not the case here. Well, unless there's good cause for not doing so. And so in the case here, conservation objectors' objections, all of their objections in this case, were either addressed under summary judgment on the beneficial use component, or they settled all of the remaining objections. So at the administrative level, any standing issue became moot. And the standing issue didn't arise again until they filed their motion or their PJR. And once that was filed, then standing became an issue. And Tintina made the elected to bring that up, in this forum, because it's this court that's going to make that decision. And so there is no merit to the argument that they were not timely. Second, conservation objectors point to Trout Unlimited versus Beaverhead Water for saying that they have generalized standing with the Water Use Act. That is an incorrect reading of Beaverhead Water. Beaverhead Water was looking at standing within the adjudication process. And in the adjudication process, the court noted there is no limit on standing on who can file an objection. In fact, the court said that it's desirable to allow even remotely affected interested persons to oppose opportunity to participate. So there is no restriction within the adjudication. There is a restriction within the permitting statutes. And the permitting statutes give an entity the right to object when they have property, water rights, or interests that would be adversely affected by the proposed appropriation.
How are their interests not adversely affected under their allegations, their theories?
Well, adverse effect has a specific meaning in the Water Use Act, particularly in the permitting statutes. And in the statutory criteria that DNRC looks at in issuing a permit, the adverse effect is that the water rights of a prior appropriator under an existing water right, a certificate, a permit, or a state water reservation will not be adversely affected. So the only interests that DNRC is authorized under the statutory criteria to review are the effects on prior appropriators under a water right.
I'm sorry, so where does the reserved rights fit into that?
Water reservations is one of the prior appropriations that
So they have to be protected.
they have to have a legal interest in a water right to be able to have standing.
So if we were to hold that the dewatering was a beneficial use, would you agree then that the reserved water rights for the recreationists here, that they have standing?
I would disagree, Your Honor, and because the water reservations are not the public water rights that conservation objectors allude to. Water reservations were specifically made by legislative intent to reserve water for municipalities in future growth. It's a little bit tied into the growing cities doctrine. And so those are very specific. They're not the public water rights that are referred to by conservation objectors. And that actually brings up my next point, which is that conservation objectors have provided no authority for this assertion that they can stand in the shoes of those federal and state agencies that actually own in-stream water flow rights that protect fisheries and recreation. And it is standard in a court case that a party must assert their own legal rights and interests. And conservation objectors simply have no water rights that they are protecting. Now, there are limited circumstances where a party can stand in the shoes of a non-participant third party. But those are very specific, and the litigant has to show that there's an injury in fact to that litigant, that there's a close relation to that litigant and the third party, and most critically, that there's a hindrance to the third party from being able to participate in the case. In this case, Fish, Wildlife, and Parks, which is one of the entities that owns water rights in the drainage, participated in this proceeding. They objected to 4 of the change applications that were part of the mitigation plan that Tintina had processed, or that was part of the entire suite of applications that made up the permit. And those objections were resolved. But certainly FWP was fully aware of what was going on, what the decisions of DNRC were with respect to both the mine permit that was issued and to the decision by DNRC that mine dewatering standing alone was not a beneficial use of water. And they could have stayed in this case and objected to that. They did not. So in sum, as council has said repeatedly, it is the purpose of the Water Use Act, particularly the permitting statutes, to protect senior water right holders. Conservation objectors just do not have any senior water rights that could be affected in this case.
So I'm not as familiar with the record as you are. You said that the objections that were lodged by FWP, that there were 4 specific objections and they got resolved. How did they get resolved?
Tintina and FWP negotiated some, basically some changes that were made to those applications, and Tintina agreed, and they were embodied in the DNRC's permitting of those, or approval of those applications. I wanted to correct just a couple of other things quickly. I'm running out of time. In the settlement of the conservation objections, Council had mentioned that the effects on Black Butte Creek. Conservation objectors in Tintina agreed that Tintina would mitigate 100% of the net depletion of Black Butte Creek, not just the portion that was at 350, the entire model depletion. And so that is an incorrect statement to pull in Black Butte Creek. That was a specific component of the settlement that conservation objectors made with Tintina to settle out their objections.
Council, but that tributary is still going to be depleted for a certain period of time.
No, ma'am, that's not correct. The Tintina is not depleted. Tintina is mitigating all of those depletions 365 days a year.
But the 457 other acre feet, we don't know what it's doing to.
Not with respect to Black Butte Creek. With respect to Black Butte Creek, the entire model depletion, the whole 807 is being mitigated in that particular creek via settlement agreement with conservation.
Can you point to where that is in the record?
It is in the settlement agreement.
Well, it's all right. Don't take your time. Maybe
It is in the settlement agreement that it was attached to the briefing at the motion to withdraw the objections at the contested case proceeding.
Okay.
I'm sorry, I don't have that citation
That's
for
okay.
you. Thank you.
We have fine clerks from the University of Montana that'll help us find that in the record.
May it please the court, my name is Brian Bramblett. I represent DNRC, the appellee in this case. I'm here today with co-counsel Molly Kelly. I hope I have time to discuss 3 reasons why the court should affirm DNRC's decision. The first of those is that DNRC's interpretation of law is consistent with the Water Use Act's primary objective, which is to protect water rights as a property right. In this case, the water drained from the mine for disposal is beyond the reach of the Act because it doesn't have the essential characteristics that make a water right property. Second, the Water Use Act and Montana case law establish that drainage and disposal of water is not a beneficial use of water. And then finally, DNRC's interpretation of the law is entitled to deference. It's been in place for over 40 years. It's consistent with the language and the context of the Water Use Act, and it's relied on stakeholders throughout Montana. To my first point, in Clark Fork Coalition v. Tubbs, this court explained that the Water Use Act is designed to strictly adhere to the prior appropriation doctrine, which is the Act's core purpose. That doctrine's first in time, first in right rule has one objective. It protects property. It excludes others from property. In Clark Fork Coalition v. DNRC and RC Resources, this court explained that the Act does this in the following ways. The adjudication establishes the extent of pre-1973 water rights. The permit process establishes the extent of new water rights. And the centralized database maintains those water rights in order of priority. The Water Use Act changed the process for adjudicating and obtaining water rights, but it didn't alter the bedrock principles regarding the elements and limits of a water right as property. The permit criteria balance entitlements or new entitlements with existing entitlements, and they protect seniors. However, those entitlements and protections only apply if the threshold property requirements for a permit are met. Draining and disposal of unwanted water from a mine doesn't meet the most critical of those elements, which is beneficial use. This brings me to my second point. Beneficial use is a term of art that's been around since the inception of Montana water law. As a water right is a usufructory right, and that means that you have the right to make use of the water. You don't actually own the corpus of the water. Accordingly, beneficial use is the basis, measure, and limit of a water right in Montana. And I want to talk about two early opinions from this court. In Power v. Schweitzer.
Counsel, how is what Tintina is proposing not using the water?
Well, there are two reasons why it's not using the water, and I think that the cases I'd like to discuss will help explain that. So I'll start with the first, and the mere act of diverting water has never been constituted a beneficial use in Montana. And there are some questions about whether or not impoundment was a beneficial use that were answered by counsel for the appellants, where he said, yes, it was. No, it's not. Impoundment is merely, just like storage, it's a method of conveyance. It holds the water, but it does not use it. In order for you to have a beneficial use water right, where you're impounding water or storing it, you have to have it associated with a beneficial use. And second, the incidental benefits from draining the mine have never been considered a beneficial use in Montana. And I'll use Power v. Schweitzer and West Side Ditch to explain that. So in Power v. Schweitzer, the plaintiff benefited. He diverted a certain amount of water, and after he was done using it, it spilled over and grew hay crops that made his land more valuable. He attempted to get a water right for it in a dispute, and the court said, no, it wasn't your intent to use the water for agriculture. Accordingly, you're limited to what you actually intended to beneficially use it. So the incidental benefit of growing that crop was not a beneficial use for which he could acquire a water right. Likewise, in West Side Ditch, the defendant in that case benefited from draining his land. It made it more valuable. However, the court said his only intent when he drained the land was to get rid of the water. It wasn't a beneficial use. Accordingly, they didn't acquire a water right in the water that was drained. And he didn't acquire a water right until 25 years later when he attempted to put it to beneficial use. Those cases, so Power v. Schweitzer was decided in 1898, and West Side Ditch was decided in 1938. They're bedrock principles about beneficial use that are not satisfied by drainage in this case.
Mr. Bramlett, and this may show my ignorance about the Water Use Act and how it ties into those old beneficial use standards, but one thing I'm concerned about is the notion that under the new law, if you're going to get a permit in a closed basin especially, you've got to show no net depletion or mitigation of that. And so even if the mine isn't using the water or putting it to a beneficial use, it's up to the applicant to demonstrate that. It's not up to the senior water rights holders to come back later and say, we're being harmed. And so if we just don't know whether there will be a net depletion, how does that meet the intent and the language of the Water Use Act? Do you see what I'm concerned
I think I
about?
understand what you're saying, and I think it comes to that threshold question. So what seniors are protected from under the Water Use Act is the encroachment by junior water rights. And if there's no need for a water right for the activity, it just doesn't fall under the scope of the act.
But the reason they're protected from encroachment by junior water rights holders is so the water's still there. I mean, that's the whole point, is that they need to be able to use the water they're entitled to. And that's why junior holders can't come in and interfere. And so if the net effect is going to be that the water just isn't there, how does that fit with the law?
I guess my response would be that under 85-2-114 and common law, senior water right holders, as the owners of property, still have remedies available if someone has interfered negligently or intentionally with their water use.
Well, I mean,
It's
we
not-
don't know what the evaporation is going to be, right? I mean, and what if it's a lot, right? Then we go sue for water that doesn't exist anymore because we've used it up. I mean, it's disappeared into the air.
Well, first, I don't think there's any evidence of record that evaporation would be a lot.
It would be a lot, right? I don't know. I'm just saying that your opponents here have told us there will be evaporation of some kind. They're holding it for 3 months. You have no idea what that is.
Well, so there are other storage ponds for beneficial
Okay.
use. And
But we
the-
haven't studied that, so we just don't know, as Justice Baker said, of what we might lose. I mean, it isn't exactly the same analogy of putting your cell phone one to the other pocket, right? I mean, maybe you take the cover off and put it in the other pocket, but it's not quite the same.
And, I think that those are the limits of the Water Use Act. It is not intended to comprehensively regulate everything related to the water use, the water resource. It's strictly limited to regulating water rights. And if a water right isn't required for an activity, then it is not evaluated, that activity is not evaluated for net depletion or impacts.
So along those same lines they're anticipating that there will be 807 acre feet per year, but the permit is for 350, and basically that other 457 is, you're just saying you're powerless. So it may not be, whether it's 807 or whether it could be double that, there's no control over that.
That's correct, from the department's authority under the Water Use Act and permitting.
So then circling back to, so the remedy for these, and following up on both Justice Baker and Justice Gustafson, the remedy then you're saying is that the farmers, the ranchers in the area, if Sheep Creek runs dry because they've been, diverting 1,600 acre feet of water, is just, they have to sue.
That's correct, and I do think it's important to remember, though, that there's no evidence that Sheep Creek is going to go dry.
No, I know, but my point is, and I agree that this is hypothetical, but my point is that there is the department is saying it has no authority beyond the 350 acre feet that the permit was granted for, and that anything above that, whether it's 807 or whether it's 10,000 acre feet, and I'm illustrating that, I understand that's absurd, but there is just no control over that, about how much they'll divert beyond the 350 acre feet.
That is something that was, it's outside the scope of the permit process that DNRC has authority over, because it's not being beneficially used.
So I appreciate what you're saying about the limits of the Water Use Act, and I guess then the next question is, if that is the statutory limit, does that run into the plaintiff's constitutional argument that interpreting that statute doesn't comport with the intent expressed in the Constitution of a comprehensive regulation?
No, I don't believe so, and there are a few reasons why. First, if you look at the Constitution, Article 9, Section 3, it's entitled Water Rights. It's not entitled Water Resources. It's entitled Water Rights. So it is specifically addressing the property interests in water. And then second, if you read the language in the Constitution, what it provides is that it'll recognize and confirm existing beneficial uses, and it will provide that the legislature shall provide a basis for new beneficial uses. And so if this is not in fact a beneficial use for which a water right's required, it simply doesn't fall under the Constitution's protections. And it is, even if the court were to conclude that this is a beneficial use, it's a statutory issue, not one of the Constitution. I'm going to skip forward a little bit.
Well, I just want to point out that the provision does provide that the water belongs to the state and to its citizens.
Yep, and we agree. We take
It's
that
not just a
responsibility very seriously, but the legislature has put constrictions on the extent to which a permit is required. And to that point, you know, DNRC's interpretation of the law has been characterized as a loophole. And I'd say it's not a loophole, it's actually the limit of the law. And if you read the Kenyon Noble decision, what you'll see there is that in Kenyon Noble, the gravel mine operator actually sought a permit for both the water being used in the gravel washing operation and the water being removed and disposed of. And DNRC concluded that a permit could only be issued for the amount that was actually being beneficially used to wash gravel, and that the amount being disposed of wasn't subject to a permit. In doing so, it didn't carve out an exception from the Montana Water Use Act. It simply recognized the limits of a permit under the Water Use Act as a property right. And so I think the characterization of a loophole is not an accurate reflection of DNRC's historic interpretation of the issue. I would like to, I've got a very short amount of time left here. I think that the appellant's short-term objectives regarding Tintina's mine will have long-standing impacts on others. And I think that the municipal stormwater systems is a good example. So a stormwater system diverts and impounds rainwater and snowmelt that would otherwise discharge the surface water or recharge aquifers relied on by senior water rights. The intent of a stormwater system is to remove unwanted water from streets, sidewalks, and parking lots so those can be used by citizens within a town. These,
Go ahead, finish.
okay. These systems provide countless benefits, including flood control, erosion control, water quality protection, and water quality compliance. Like mining, municipal use is listed as a beneficial use in 85-2102. However, the incidental benefits of diverting and impounding the water don't transform that stormwater system into appropriation for the same reason the incidental benefits of removing water from a mine don't transform that removal into the use for mining. If the appellant's binary reading of beneficial use or waste is adopted, Montana city and towns that operate stormwater systems are either in violation of the Water Use Act because they don't have a permit or they're wasting water. With that, I'll sit down. Thank you.
Perhaps you could address the last point, how it's going to affect stormwater use by municipalities.
Your Honor, I think stormwater is an activity that has not been challenged in Montana previously. I don't think that would change under this interpretation. I also think it's worth noting again, in their arguments purporting to address the plain language of the Water Use Act, the state and Tintina fundamentally ignore the language and structure of the Act. Under Section 306, first of all, it is the state's obligation to look at applications of water within the state and make determinations as to whether permitting is required. Again, under 306.8, I believe, the penultimate provision of Section 306, if DNRC determines that there are activities happening within Montana that are not currently permitted and should not be permitted, but otherwise fall within the meaning of appropriation, DNRC can adopt a regulation. So effectively, what DNRC is asking this court to do is excuse its failure to fully implement the act by rewriting the statute. And this court cannot strike words from the statute. It cannot add words to the statute. And so to the extent that there are things DNRC would like to be exempt from the statute that currently are not exempt, it needs to do a rulemaking.
Counsel, that's not accurate. This is a pure question of law about what the Water Act requires and when its requirements are triggered. Now, I understand you're representing a client who's trying to advocate an interest here, but we're talking about a pure question of law and what this statute says, when its requirements are triggered, when they're not. And I don't see that it's useful to discover that or even discuss that, to cast aspersion on the agency who's trying to operate within the framework of the statutes that the legislature have limited it to.
Well, with respect, Your Honor, I think the problem in this case is that DNRC is not operating in those limits. It has not fully implemented the requirements of the Act. And I think a useful point, the question of this interpretation's constitutionality was raised during the state's presentation. And I think if you look at Section 10106, again, this is the legislature stating for the people of Montana what the fundamental purpose of this Act is. It's to comprehensively regulate water use for the protection of senior rights, and to extend DNRC's authority to the fullest extent possible to protect existing rights. So DNRC is charged by this statute with doing what it has to do to make sure existing rights in the state are protected. And what we have is an agency that is coming to this court with a non-regulatory, unstated exception.
I don't disagree with you about that, counsel, so I'm going to be very clear about that. You're right about that. The problem with that argument is that authority and duty that they're charged with can't contravene the limitations that the statute already imposes upon them. That's my problem with that idea.
You're right, that they cannot contravene the statute. I think the problem here is that DNRC is attempting to add requirements to the statute in order to avoid subjecting mining operations like Tintina's to permitting. And that, this court has made clear, agencies cannot add to statutory requirements. It has
what are they adding?
Well, again, it helps to go back. The state and Tintina in this case have encouraged the court to kind of rummage around in the common law to find some exception for mine dewatering. What they haven't done is offered you an analysis of the actual words of the statute and their ordinary meaning. So when we come back to this word use, right, beneficial use is the use of water for the benefit of someone. What is the use of water? Tintina, in its brief, offered a couple of dictionary definitions which note that use is the employment or control of something for a purpose. Tintina, at its mine, in order to do mining, it cannot engage in mining without this activity. It is going to pump and impound for months at a time large volumes of the public's groundwater. That is subjecting water to Tintina's control. It's employing it for a purpose. And I think it's really important, the Water Use Act, and this court in Montana Trout Unlimited versus DNRC and other cases has persistently taken the perspective of a senior rights holder and asking, if we allow this, what would the impact on a senior rights holder be? And with respect to Tintina, its theory of non-use creates this anomaly where the water it is pumping and impounding at the Black Butte mine is not being used by Tintina because of their kind of, I can't quite make sense of their arguments, but they declare ultimately it's not being used by Tintina, but it would be unavailable for use by anyone else. And under the Water Use Act, the notion of unused but unusable water simply makes no sense. While this water is under Tintina's control, it's being used, it's being dedicated to mining purposes, and the company wants to be pumping and impounding it. Sorry, Your Honor.
That kind of gets into the standing issue. If we take the perspective of senior water rights holders, how do you fit?
The Tintina standing arguments in this case, I should say in this appeal, because this is the first time they've appeared in the case, are striking in a number of ways. First of all, under Section 308 of the Water Use Act, the ability to raise objections to a proposed diversion of water are not limited to people who themselves hold water rights. It notes property rights or other interests. The appellant organizations demonstrated in their objections profound interest in the health of the Smith River and the publicly held water rights that secure the Smith River's health. And so this is a case where the appellant organizations have a clear interest in the waters that Tintina's pumping and impoundment will clearly deplete. So the notion that they have no interest here is simply at odds with the facts, and it also ignores the language of Section 308, in which the legislature did not limit this objection process to senior rights holders. And I think one of the things Tintina's standing argument betrays is a fundamentally private view of the state's waters. It wants the objection process, it wants litigation like this to be limited to people who have a water right. And that is a perverse argument to make under a constitutional provision that recognizes all of Montana's waters belongs fundamentally to the public, even after it's appropriated. Appropriated uses are public uses. And this court in Beaverhead Water noted that the public has an interest as the ultimate owner of even appropriated water to step in and ensure that activities like Tintina's do not cause harm to senior rights, do not cause harm to in-stream flows, and that Montana's public waters are protected.
So
Under that argument, it seems like then there is no standing requirement. Anyone in the public could be here making this argument, and we throw standing out the window.
Well, that's not right, Your Honor. I mean, under Section 308, again, it talks, you have to demonstrate that your interest will be adversely affected. So what we did in our objections to the agency, we noted these groups and their members have distinct individualized interest in the well-being of the Smith River. Can I finish answering the question? And that those interests would be adversely affected in a unique way to those organizations. And I should say, finally, the objections were deemed valid by DNRC. DNRC recognized the appellant organization's standing, and Tintina thought enough of the organization's standing to enter a settlement agreement with the appellant groups in front of DNRC, so I don't think standing is a legitimate issue, even if it was one the court could consider, which it cannot. Absent further questions, I will stop there. Thank you, Your Honors.
This concludes the argument on this, what I think most of us would agree is an extremely interesting and important case. Thank you to all counsel. We will take this matter under advisement and issue an opinion in due course.